In this case, Mrs. Benecke owned a couple of expensive Sydney properties subject to a mortgage from the National Australia Bank. She fell behind on her payments and the bank sought to repossess the homes. However, Mrs. Benecke didn't want to go down without a fight, and so she alleged that the bank had been guilty of unconscionable conduct in signing her up to the mortgages. Like many legal disputes, this legal dispute settled. The court was asked to make orders giving effect to the settlement and did so. Later, though, Mrs. Benecke asked the court to set those orders aside. Her argument was that the solicitor had caused, in her words, chaos and treachery, and had served her up as a sacrifice to the bank. In other words, she claimed that her solicitor had agreed to the settlement without her instructions. The judge, of course, then had to work out whether that was true. Had the settlement in fact been established without her instructions? The only way the judge could find out for sure was to hear from the solicitors too. Problem is, of course, that communications between a person and their legal representative are confidential and privileged. How could the solicitors give evidence to the court if the very things they intended to say were bound by privilege? The court found that because the client had raised the issue of those communications, because the client had turned the communications into an issue before the court, they could no longer rely on the privilege. Justice of Appeal Clark said, if the solicitor had been unable to give evidence, it would have been necessary for the judge to decide the case upon the uncontradicted evidence of the client. The injustice of such a situation needs no emphasis from me. However, the law did not require the judge to act in that way. The appellant, in making her assertions that her lawyers compromised the proceedings without her consent, opened up the question of the authority of the lawyers to act as they did, and she thereby waived her privilege. I take this to be clear as a matter of legal principle on grounds of basic fairness. From this case, we learn that a solicitor is not bound by client confidentiality if the client themselves turns those communications into a legal issue. By doing so, the client waives their client legal privilege.